This is case number 23008-159CH, Duda Balshan versus Duda.
Council appearances for the record.
Good morning, Honor. Neil DeBlois here on behalf of the plaintiff, Dorota Duda Balkan.
Jolanta Jadowicz-Urbaniak on behalf of the defendant, Violeta Duda Rache.
Okay, today is the day and time set for the court to give its ruling as a result of the trial that was held on July 2nd and 3rd of 2025. The court heard testimony from the plaintiff, Dorota Duda, her sisters, Violeta and Agata. The court also heard testimony from Paula Balcher, the daughter of the plaintiff, as well as the husband of Violeta. The court had expert testimony, and testimony from the notary, Claudia Rosner. The court also heard expert testimony from the handwriting experts, Ruth Holmes and Dr. Fennell. The testimony was uncontroverted from the sisters that the mother did have cancer, and she initially underwent surgery. I think I had that date. Sometime in the early part of January 2019. And at that time, before she underwent her surgery, she had a power of attorney prepared, which indicated that the property known at 2043 Edwin Hamtramck 48212 would be the property of her three daughters, Dorota, Violeta, and Agata. And that document was signed and notarized by her prior to her having any surgery, when she just learned that she had cancer. It was noted from the testimony of all the daughters that in 2020, late 2020, the mother started having some severe problems with her health. She was hospitalized in December 2020, multiple times. She was hospitalized December 7th through December 9th, then December 14th through, I believe, the 19th, and then lastly December 23rd, and she expired January 5th, 2021. During that time frame, we note that she was under the care of her daughter Dorota as well as Violeta. And we know that Dorota lived in the same home with the mother during that period of time. The issue that brought this matter to the court was a deed that was allegedly signed by the mother on December the 14th of 2020. And the question arose relative to that document that was presented to the court. The court notes, as I indicated, that the mother was hospitalized multiple times in December of 2020, and the hospital records show the condition of the mother on those multiple hospitalization. It also talks about the fact that she was provided oxygen at home. She had fluid on her lungs. She was provided opiates and morphine on multiple occasions. The court also noted that in the medical records that during the admission date of December the 7th, 2020, the goals and the care instructions from the doctor indicated that there had been the need to have discussions of end of the life and the cold status, but the daughters didn't want to talk about that. And that was even discussed during a prior hospitalization, which was prior to the December the 7th hospitalization. And as the court indicated, there are multiple notes that the mother was given morphine and other opioids to attempt to reduce the pain. The main thing that the court also notes is that, as it's been testified to, was that the mother did have a psychiatrist and had been seeking psychiatric services for a significant period of time. And during November, when the mother visited with her psychiatrist, the psychiatrist noted that one, the mother was on morphine for pain. Her mood was depressed, sad, her voice was low, tearful. She also indicated that there was a statement provided to her that while the mother was in the hospital, and this was in November, that she was hallucinating and that she thought that she was in Poland and that she did not recognize her daughters. That's in November of 2020. And then the psychiatrist, of course, confirming that her speech, and this was as late as November 24th, that the mother's speech was slow, her voice was low, she was easily exhausted, and she complained of pain. And during that November 24th session, the psychiatrist ended the session after 50 minutes due to the patient's condition and her being tired. Like I said, the court had the testimony of the daughters, and the court has to, in turn, make a finding based upon the preponderance of the evidence, take everything into consideration in terms of credibility, the likelihood of somebody giving truthful testimony versus something that may be somewhat skewed. The court also noted that we talked about and had the testimony of the notary, and when the notary allegedly appeared in the home, which was allegedly on December 14th, the day that the mother was hospitalized, the notary indicated that she did not come into the house all the way. She stayed in the hallway. This was as a result of this being during the COVID time, and that she did see the mother sign, but that was her limited experience with the mother on the 14th. The court also noted that we had the testimony of the two handwriting experts, and Miss Holmes, she provided the court with her analysis and the fact that she compared multiple handwritings, and the handwritings that from her opinion that the handwritings were not the same on the deed and those with regards to what the mother had prepared. Also, we had the testimony of Dr. Finoff, and Dr. Finoff's testimony was that relative to the fact that one, he didn't have any quote unquote signatures, that the level of the probability that the signature was, in fact, the mother's was low. And one thing the court noted from Dr. Finoff is that he was attempting to say that he didn't have quote unquote signatures, but it should be noted, and the court, in looking at the legal documents of the mother really never used full cursive writing. In looking at her passport, in looking at her license, she primarily did a print script type of signature, which really didn't lend itself to cursive writing. So as the Dr. Finoff indicated that there was no minimal cursive writing to use as a comparison, mother very rarely did use a cursive writing to sign any legal documents. The court, can use its common sense. The court can use its life experiences in determining what it believes to be accurate and what it does not. And as the court has indicated, one, the mother was at the time when, if this was done, at the time that it was allegedly done, she was at her end of life. She was clearly at the end of life. Her health was deteriorating. She was on significant medications. So if in fact she did sign it, and like I said, the court said this is not something that she usually would sign, so that's problematic in and of itself. So if she signed it on the morning of the 14th, she was definitely not in her right mind. She was not well. She was at end of life. And that was indicated, if she signed it on that date, that this signature was not her normal signature. As I've stated, and I think I stated, on that date, on the 14th, she was taken to the hospital. Her oxygen levels were out of sync. She had extensive fluid on her lungs, and there's no way that she could have been strong enough to sign it if, in fact, it was signed on the 14th. As we know, her life, she expired within 2 weeks or so, 2 to 3 weeks after that hospitalization on January 5th. So the court, and also the court like to note that Dr. Finoff, in saying that there was a low probability, he even suggested that the court look at other forms of evidence to formulate its decision. And one, the court looked at the fact that, one, the mother did sign her power of attorney back in January the 30th of 2019. And the court, as I indicated, that's her print script signature that she usually does. Additionally, the court looked at the other legal documents that she signed, and it's traditionally that print script. So if that was by her hand on the 14th, it wasn't her usual hand. Also, the court, it was their inquiry as to the notary, what she observed the mother. She couldn't say that she observed anything out of the ordinary if this was on the 14th. She also indicated that she was not in the room due to the COVID. So in terms of her being able to discern the mother's condition, she wasn't in a position to do so. So what we have here is, one, the court making the determination whether or not the mother was in her right mind to go forward and sign anything on the 14th of December when she was approaching the end of life stages. And the court finds by the preponderance of the evidence that she was not in a condition to sign anything on the 14th of December due to the fact that, one, she was at the end of life, two, her had been on morphine and opioids, and even though the daughter claims that she did not want to give it to her, she had been hospitalized multiple times. And as the court indicated, it could use its common sense and any of its life experiences, and knowing that elderly people do not recover from any type of medication in the sense that she would be able to bounce back in that time frame that she had. One, like I said, she was hospitalized in November. She was hospitalized early December. And again, she was hospitalized on December the 14th on the date and time that she allegedly signed this. And that's problematic in that somebody's about to go to the hospital and then there's going to be this need to hurry up and sign a document. Additionally, we know that Dorota never provided her siblings with this deed until it was brought to the attention by Violetta that, one, the sign was on the yard, and then Violetta did additional research and found that it was for sale online. And the sisters had conversations, and there was never a time when Dorota raised this with her sisters, even though they had multiple conversations. And as we know, there's property in Poland, and the property in Poland was divided amongst the three daughters. And here, the verification that we have that the mother's wishes was to divide the property here in the United States with the power of attorney. Even though it was not a deed, she made it clear when she was of sound mind and body that she wanted the property located at 2043 Edwin Hamtramck Street to go to all three daughters. And we know that this was written in Polish so that the mother clearly understood and knew what she was signing. In terms of the deed on the 14th, this deed is in English. There is no indication that the mother even knew or had knowledge of what she was signing and the extent of what she was signing. So even though she signed it, even if it were signed on the 14th, and the court questions whether or not it was signed on the 14th, due to the fact that this was the date and time when the eve of the 13th, Dorota called Violetta, telling her of the mother's condition and that they needed to take her to the hospital. So that was 11th hour to coin a phrase, Hail Mary, if it was signed on the 14th, to get the mom sign it. And the court does not find she was in any shape to sign any documents on the 14th. And as the court indicated, her mother's indications were all clear that she wanted her daughters to share, not only by the quitclaim deed, but also how she divided the property that was in Poland. That being said, the court finds by the preponderance of the evidence that this deed was not valid, that it was not properly executed, and that it does not have any merit, and the court will nullify the deed in terms of that, and the court will, upon preparation by defense counsel, enter, I can't remember, the appropriate documentation that will have to go to probate court, indicating that this property is to be shared by all three daughters. So, Ms. Urbaniak, I'll look for the documentation to be presented to the court, and the court will sign the same.
All right, Your Honor, I will prepare the order. Your Honor, will the court also address the rents, a constructive trust, or, the accounting for the rents that have been?
You need to do a separate motion for that. You need
Yes.
to do a
Okay.
separate motion for that.
Proposed trial motion.
Right, a post-trial motion in terms of the rents that were accrued, and we'll do that post judgment.
Should I also address the attorney fees and costs in that motion?
Yes, you can, yes.
All right, Your Honor.
And then that'll give Mr. DeBlois an opportunity to respond. And make sure once you prepare it, you present a hard copy to the court and make sure that it's precipied.
Yes, yes, Your Honor. I will do that.
Okay.
Thank you.
All right. Thank you. And that concludes this hearing, and I'll see you post judgment for the motions.
Thank you, Your
Thank you,
Honor.
Your Honor.
Thank you all.